moving on to the parties' remedies after there's been a breach. I want to talk about anticipatory repudiation. What if, before the time of performance, one party clearly communicates to the other their clear intention not to perform? Is that a legitimate excuse? They literally acknowledge their party's obligation under the contract, but they say, nope, not going to perform. In January, Bell, a clothing manufacturer, contracts to buy a large amount of woolen fabric from Surge's material mill. The contract specifies the price is $4 a yard, payable 30 days after Bell receives delivery. The date of delivery is March 15th. In February, Bell receives a letter from Surge's that says, I'm sorry, I must rescind our agreement. I hope we can work together in the future. What result? What are Bell's options? Is this a rescind? Is this a valid rescission of the contract? I don't see the contract calling for a unilateral end deal here. It's a promise of a promise. No, that's not a proper rescission. It's what we call a repudiation. It's a clear communication that a party's not going to perform. So what are Bell's options? Bell could let him off the hook, and then the rescission would be by mutual consent. Bell could await performance by Surge, hoping that he'll decide to honor the contract, because performance date is until March 15th, so she can wait. And she doesn't have to tell him that. She can just wait it out and see what happens. Or her options are to resort to any remedy for a breach, which is where we are going to jump in here. But either way, under any choice that she chooses, because there's a clear communication, she can suspend any performance on her part. And if we're talking about a situation, we don't have it here, but in this example, but if the seller has a right to then resell the goods, or if the goods were unfinished, they could salvage the goods. But we don't. That's not relevant in this example, but that's another option that's available. So let's talk about the remedies that a seller has when a buyer breaches. First of all, but that's my rule for anticipatory repudiation. There has to be a clear communication to the other of the clear intention not to perform. Okay? And we just discussed what the options were. We talked a lot of remedies available under the common law: compensatory damages, specific performance. We had incidental damages, consequential damages. Those all apply here as well. We're going to talk about those a little later on, but they're available under the UCC as well. But other remedies that are available to the seller when the buyer breaches: they have the right to withhold delivery. So if the buyer doesn't pay, if there was an upfront payment before delivery, buyer doesn't pay, you have the right to withhold delivery. Whether if there's a wrongful rejection of the goods, or if the buyer revokes acceptance, as we learned just a little while ago. They have the right to reclaim goods on buyer's insolvency. Remember, insolvent, they're in debt, they have more debt than assets, and then they can't pay their bills. The seller can go in and reclaim their goods, especially if the buyers receive those goods on credit. And the key here is they must make demand within 10 days of the buyer to return the goods. Okay? And this is especially if the buyer has received the goods on credit and they misrepresented their solvency. So a right to resell goods. They have the right to resell goods if the goods are still in the possession of the seller or in the hands of a bailee or a carrier. Basically, the buyer doesn't have them yet. The seller has the right to resell goods if there's a breach on the part of the buyer. And they can, under the right to resell, if the goods are unfinished, the seller can stop manufacturing them and resell them as scrap or salvage. Or two, they can finish manufacturing and sell them or dispose of them. But in any of those situations, the seller can recover any deficiency between the resale price and the contract price along with any incidental damages. And we know what those are. Those are damages resulting from the breach of contract, including all reasonable expenses incurred because of the breach. So the seller has some options here, and they also have the right to recover the purchase price. So under the right to recover the purchase price, an unpaid seller can bring an action to recover the purchase price or payments due under the contract and any incidental damages only under one of the following circumstances. The buyer has accepted the goods and has not revoked acceptance. When conforming goods have been lost or damaged after the risk of loss is passed to the buyer. When the buyer has breached the contract after the contract goods have been identified and the seller is unable to resell the goods. And under this situation, the seller must hold the goods for the buyer. If the buyer resells the goods, of course, he has to mitigate the damage. So if the seller resells the goods, the net must come off of the collection of any judgment from the buyer. So for example, Dixon Management Consultants contracts with GemPoint to purchase 1,000 laser pointers with the company name inscribed on them. GemPoint delivers the laser pointers, but Dixon refuses to accept them. Does GemPoint have a remedy for the full contract price? Yes. It delivered conforming goods to Dixon. Dixon refused to accept or pay for the goods. They cannot resell the goods because it's got Dixon's name on it. So the seller doesn't have to just pick one of these options, but in this instance, can collect the full remedy of the price here. And like I said, there could be multiple options available to the seller. He's not just he or she is not restricted to just one. And they have the right to recover goods. The goal here is to put the seller in the position he would have been in had it not been for the buyer's breach. So, what can the seller recover? Generally, the seller can recover the amount of damages that equals the difference between the contract price and the market price at the time and place of tender of goods plus incidental damages. But you might be thinking that may not put the seller in the position he would have been in had he not been breached. That's the general concept of damages that we start with. It's the amount of damages that equals the difference between the contract price and the market price at the time and place of tender of the goods plus incidental damages. And sometimes this amount is too low to put the seller in the position he would have been in had he not been for the breach. But there's other damages that the seller, like I said, is allowed to collect. There isn't just one option. So seller's lost profits is included in reasonable allowances for any overhead is included, and like I said, any incidental expenses. And I'm going to have some examples in the ones that are recorded in the separate sheet with regards to damages that are available. So what are the buyer's remedies when the seller breaches? Well, the buyer can recover any money that they already paid, for example, like a down payment. They have the right to rejection of the goods. We've already discussed the rejection of goods and what happens with a tender of delivery and it does not conform and the buyer rejects everything. They can reject everything, accept everything, or accept partial, reject partial. But what if, the rules regarding their rejection, it must be timely and it must be reasonable. So they must do it within a reasonable time. They can't hang on to the goods for 3 months and then say, I'm rejecting these. It's not conforming. So they have to do it within a reasonable time. And the merchant, if we have a buyer who is a merchant and they rightfully reject goods, that buyer is required to follow any reasonable instructions received by the seller with respect to the goods that are ultimately in the control of the buyer. For instance, what if the goods have to be refrigerated? What if these goods have to be attended to or they get ruined? So if there's any special instructions from the seller with respect to the goods and the buyer is a merchant, they must follow those reasonable instructions. For example, another example is to hold the goods until the next day in order to retrieve or ask to ship them back. Of course, under both of those scenarios, that would be at the seller's expense because it's the seller's breach. They have the right to obtain specific performance. We've used that term before under equity law when monetary damages are inadequate to remedy the breach. For example, Sutherland contracts to sell his antique car to Jerry for $30,000 with delivery and payment due on June 14th. Jerry tenders payment on June 14th, but Sutherland refuses delivery. If Jerry sues Sutherland, can Jerry obtain the car? Yes, the car is unique. Jerry may be able to not be able to get that kind of antique car anywhere else. So this would be a specific performance case. That also works, with a work of art. So, right to obtain specific performance. Then we have this concept called right to obtain cover. And that allows a buyer on the seller's breach to purchase the goods from another seller and substitute them for the goods due under the contract. And after purchasing substitute goods, buyer can recover the difference between the contract price and the cost to cover, plus any incidental and consequential damages, okay? That the loss suffered by the buyer that was foreseeable. Remember the consequential damages? Loss suffered by a buyer that was foreseeable to the seller at the time of the contract. So they can get substitute goods and collect for any difference. So for example, I contract with you to buy 20,000 glow sticks for $50,000. They glow red, white, and blue in a stripe for a 4th of July parade. The contract states that delivery on or before June 30th. On June 30th, I get 20,000 blue glow sticks from you, and you cannot cure. So I have to get substitute goods, and I get them from an overseas online company for $75,000 and have them shipped within 2 days at an additional expense of $5,000. The question is, can I sue you? Yes, that was a breach. You sent non-conforming goods that cannot be cured. So what can I collect? I can collect $75,000 minus $50,000, the difference between the new substitute cost and the cost of the contract with you. So $25,000 plus those additional shipping expenses. So I can collect a total of $30,000 from you. You have the right to recover damages, a buyer. And again, there isn't just one or two options. I mean, with a specific performance, that might be the only option you get. But when we're talking about the recovery of money, there might be other one or two different avenues that can be proceeded with. Your right to recover damages, and usually the damage is the difference between the contract price and the market price at the place the seller was supposed to deliver at the time the buyer learned of the breach. And again, that might not be enough to cover the buyer's expenses. But this concept stems from the compensatory damages that we talked about under common law. And the buyer can collect the incidental, the consequentials, less any expenses that were saved. That whole everybody has to mitigate their damage. So if there was expenses that were saved, that is to the benefit of the buyer and the seller as well. So there has to be some mitigation. So generally, similar concepts under the common law. There are a few caveats depending on what's happening and what the goods are. But that's generally remedies under the UCC. I do want to talk about the statute of limitations. We did talk about it under common law. The time frame, basically a statute of limitations is the time frame for bringing a court action for somebody under a breach of contract. And I told you under the common law, the statute of limitations in the state of New York, whether you have an oral contract or a written contract, is 6 years. Under the UCC, sale of goods, it's 4 years. The parties may reduce it. They may say in their contract that if there's going to be a lawsuit, you have to do it within 3 years or 2 years, but they cannot decrease it to less than 1 year, and they cannot increase it. So the max is 4 years. And the time runs from the time of the breach, regardless of when the breach was discovered. So there might be a breach of contract, but you don't discover it till a year later. 1 year of that 4 years is already run, or if it's in a contract, the 1 years may already be up. So you want to be careful with that. So under the UCC, it runs from the time of the breach, regardless of the discovery. And that is remedies. Our next concept that we're going to talk about will be liabilities, and that will be beginning for next week.